All right, so we're going to talk about some of the things that are required when getting a divorce started, and it can be a little bit overwhelming. But I want to explain. There's 4 documents or things that get filed with the courts that you need to be aware of. Now, they're not filed in every case, but it's important that you understand it. The very first one is called the Petition for Dissolution of Marriage. That's filed by the petitioner, or the person that's filing the divorce. The other side is known as the respondent. Now, the respondent has to then file some things as well in the case. But before we get there, the next thing is what you call a summons. Okay? A summons is a legal notification to the respondent that a petition's been filed. And this essentially means, hey, this is serious. We're no longer just talking about divorce. This is not just a bad argument. This is actually happening. So the summons, along with the petition, gets served by a process server on the respondent. Respondent then has time to file an appearance and a response. So those are the other 2 documents. The appearance is a legal document saying, I understand the case is ongoing, that this is happening, and that I represent the respondent. All communication comes through me now. Now, this appearance can be filed by an attorney, or it can be filed by the respondent themselves, essentially saying, I represent myself. Now, just because you start off representing yourself doesn't mean you can't hire an attorney later. And just because you hire an attorney doesn't mean you couldn't later represent yourself. So when you're talking about getting a petition started or a divorce started, you've got your petition, your summons, your appearance, and your response. Okay, so let's talk about fault. What is no fault? What is fault? Well, Illinois is now a no fault divorce state. Previously, we were a fault divorce state, and that meant you had to put into your petition some elements that would support what you're asking for. And really, one of the most common ones was a thing called mental cruelty. Just sounds awful. But basically what that meant was sometimes your spouse doesn't treat you nicely, and sometimes they say things that hurt your feelings. And people used to have to put that into pleadings, and quite frankly, it would make more fights and more arguments when it just wasn't necessary. So I actually agree that being a no-fault divorce state is much better because we don't have to get into proving what was done or not done. We're just simply saying it doesn't matter. I want out, you get your stuff, I get my stuff. This is how we're going to make decisions for the kids, and we move forward. We don't have to prove that you were a bad husband or a bad wife. Because let's face it, sometimes good people are bad together, and it doesn't really matter who caused it. When it comes to fault or no fault, that means we don't allocate property based upon fault. In other words, if one spouse was a terrible spouse and they had an affair, we don't now give one person more or less based upon those actions. Now, there's kind of one exception to that, and that's something we call dissipation. But that really only comes in if one spouse uses marital funds on a non-marital purpose. So if they took their, significant other on a cruise or spent a lot of money on them, that is the only time that we will look at fault in allocating property in a divorce. Let's talk about dividing property. Now, when we're dividing property in Illinois, we have to keep in mind that this is an equitable distribution state. What that means is what's fair under these circumstances. It's not equal distribution. There are some states that you actually presume 50-50 split. In Illinois, we don't actually presume it, but it is kind of done in practice. In other words, when we're starting off a case, it's very common for the courts to divide things evenly. But there are a variety of factors, and there's several factors that you would be considered in each case. How much money did the parties have before the marriage? What's their earning capacity now? What do we think is going to happen in the future? So many different things can go into play of how we're going to divide it. But the point is, what's fair under your circumstances are going to be different than somebody else's. So when you're dividing property, we have to make sure that you get a fair deal based upon your unique circumstances. And this is why it is so important that you have quality representation in your corner. Because if it was as simple as 50-50, let's face it, you wouldn't need anybody. You just plug in the formula and you move on with your life. But your situation is different. So it's important that you have somebody that understands your needs that can advocate for you. All right, let's talk about mediation in divorce. Now, I'm a big proponent of parties using mediation for three reasons. I kind of call them the three C's, but there's cost, control, and confidentiality. So let's talk about it. When it comes to cost, you're paying one party, a neutral third party, usually they're an attorney, to be there, and you and your spouse are present. But your attorneys are not. So you're going to be saving the hourly rates of both attorneys, and you're just paying for one. And hopefully that can streamline things and get you a lot closer to the finish line. So if you do it well, it's going to save you a lot of money. Let's talk about control. At the end of the day, your case is going to end with either you guys reaching an agreement or the judge will make a decision. If you and your spouse are able to work together, you maintain control. You understand what's going to happen with your children and what's going to happen in the end. The last thing is it's confidential. So in other words, you can speak freely in mediation. You can throw out ideas. You can throw out possible compromises of things, and that can't be used against you. In other words, if you throw out a plan or a proposal, your spouse can't come back in court and say, well, you had offered this in mediation. It's confidential. The judge won't consider it. So you know you stay in control. And ultimately, hopefully it will get you a resolution much, much faster. So now we understand the basics of it. Let's talk about how it's used. It is primarily used, mediation is primarily used in custody or parenting time situations. It's less and less used in financials. Really, the biggest thing is your mediator needs to understand all of the components. So in a child custody situation, there are components that are well known and well established. Whereas financial mediation, if you have one side that has more information than the other, it's not really on the same playing field. So if you have, say, a privately held business with certain structures in place, if the mediator is not familiar with those terms, then the other side's at a complete disadvantage and the mediator can't really help. So if you're doing financial mediation, it's really, really important that you have a mediator that's well-versed in the issues that are at place in your case. So if you're considering divorce, even if you're considering doing it on your own, it's a good idea to make sure you understand some of the basics and how it impacts your situation. We'd be honored to help you to figure out what the next step should be for your situation.